Here at the scene of the crime spree, right behind you.
Vice Mayor Strange, you'll address her properly.
You can kiss my foot.
Mr. Rickard, you're out of order.
FBI, we are asking you to investigate this council. Please look into this council, how they award contracts, the bid process, how they use their positions to benefit their friends and themselves, how they use their positions to attack residents and critics and neighbors and business competition. FBI, will you please look into this?
And I welcome the FBI here. If you notice, Mr. Thompson, with his plea for the FBI and his watchdog group, this city runs the cleanest in this whole county. I guarantee
He was served a federal subpoena this morning.
We did receive a subpoena this morning, and we're going to cooperate 100% with the subpoena.
And most of you who were involved up here, you gaslighted me. You tried to say I was crazy. And now we know that that's not true. And there's a lot of other issues I've been asking about as well.
If you are keeping up with the Lynn Haven corruption case, the trial is set to begin November 28th. And today was a big day. There were 4 motions filed. I'm going to focus on one of them, and I'm going to show you some really incredible stuff. The motion that I'm going to focus on is from the prosecutors, from the government, and it's called a motion in limine. And what that is basically they're at the point now where the prosecutors and the defendants are arguing to the judge, who will decide what evidence is admissible, right? What can the defendants use in their defense? Are they able to, for example, point to prosecutorial misconduct years ago from the lead prosecutor? Are they able to point out that the now deceased contractor, Derwin White, gave gifts to people at the sheriff's office, like motorcycles? Or is that off limits? Are they able to, all kinds of stuff? Are they able to bring up the false statements made to the grand jury that got the indictment in the first place? Are they able to bring that up or no? The government, the prosecutors say no. Absolutely not. Just because we made some mistakes, all right? Just because we might have taken some gifts, just because the lead prosecutor got in a hell of a lot of trouble years ago in a malicious prosecution where the Justice Department actually paid the family $2 million, or just because the grand jury heard a bunch of information that turned out not to be true does not mean that the defendants are innocent. That's what you're going to see. That's what you're going to see in this motion in limine tonight. So I'm going to go through it with you. The government is asking, the prosecutors are asking for 15 things from the judge. And I'm going to show them all to you. I cannot wait to see what you have to say about them. But here's my initial thought. It would be really nice in a place full of colossal corruption, massive corruption throughout Bay County, right? It would be really nice if the FBI and the Sheriff's Public Trust Unit and the U.S. Attorney's Office, if they would go after some of the people who brazenly committed humongous crimes and made the pickup of the debris in the hurricane, extended the hell out of that, keep the place a mess. We'll get more grants, more kickbacks. The FBI has this, the sheriff's office has this, but they're focused on this. But what would be really nice is if they ever get around to it before the statute of limitations runs out on their friends, what I'm saying is if they ever get around to charging and prosecuting the big local crooks, right? The big ones here. What I hope is that when they go to trial, that the FBI and the government and the prosecutors and the sheriff's office, the public trust unit, that they don't have to ask a judge, hey, judge, we finally got the big crooks in Bay County, the ones who have brazenly committed millions of dollars of public theft. We have the evidence, the real evidence. We got them dead to rights, judge. What would be nice is if they didn't have to say, hey, Your Honor, would you mind if the jury never saw the fact that we accepted gifts from these guys? And Your Honor, would it be okay if the jury never saw the fact that we told false statement after false statement after false statement after false statement to the grand jury in order to get the indictment in the first place? Would it be okay, Judge, if the jury never knew that? You know, because just because, Your Honor, you've said that we've been unprofessional, haphazard, and reckless, would it be okay if the jury never hears that, please? That's what they're asking. So in other words, how do the defendants defend themselves? See, if they ever get around to actually getting the big crooks in town, I hope they don't have to say that to the judge. I hope they get the indictment clean without giving misstatement after misstatement after misstatement to the grand jury. Get a clean indictment. Don't have a prosecutor whose malicious actions led the Justice Department to give a family $2 million in the past. Let's get a different guy, maybe. And let's maybe not have a lead sheriff's investigator who gets motorcycles and gifts from our targets. These are just things. Look, I'm not an expert. Now, they've got the best detectives. They've got the best prosecutors. These guys are pros. But I'm just saying it would be really damn nice if we didn't have this kind of stuff that we're trying to hide from the jury in order to get the bad guys. Right? Is that asking too much? I don't think so. I don't think it's asking too much. And it would be also nice, as long as I'm on this train, if the evidence actually proved the crimes. That would be cool, right? If, let's say, the investigators and prosecutors don't make stuff up, that would be a big deal. Really important when it gets to, the jury. But until this is reconciled, all right, we don't have time, Bernie, to go after the big crooks in town, the ones who extended the pickup of hurricane debris so that they could get more grants and more kickbacks and inflate prices. You know who they are. The FBI knows. The sheriff's office knows. But, they only have limited resources, see? I am doing my very best to bite my tongue right now and to get to the facts. So we're going to do that. We're going to get to the facts. I'm going to show you this motion in limine to hide stuff from the jury. Again, we're at the stage where both sides are saying, hey, Your Honor, this should be admissible. This should not be admissible, but this should be admissible. And there were 4 motions filed today. The one I'm going to show you is the government's motion. The 15 things that they're asking of the judge. They want some stuff brought in, and they want a whole bunch of stuff left out. In other words, there's a legal term for this. It's called stacking the deck. All right, I'm going to show it to you. I hope that you'll share it with your friends. I hope that you'll tag people, because what you're going to see is remarkable. And if you are ever being prosecuted by the federal government, I hope that there's not a list of things that the government did wrong that they don't want the jury to know about. I hope that you are never in that situation. But if you did a crime, if you actually stole from the public, then I hope that you have a clean prosecution and they get a conviction if that's what you did. But this is a mess. This is a mess. Remember, I keep telling you that I don't believe that they want this to go to trial. I don't think they want people from the sheriff's office on the stand who have to say, yeah, I got a motorcycle from him. I got all kinds of gifts. I don't think they want the FBI agent to say, yeah, I made all these misstatements to the grand jury. I don't think they want the lead prosecutor, his history laid out. I don't think Sheriff Ford wants to be on the stand answering questions. What do you mean I don't think they want to? Of course they don't want to. That's what this motion's all about, is to prevent that. If the judge allows the defendants to defend themselves by pointing to the investigators and prosecutors and saying, this is pretty dirty, it's gonna shock this place. It's gonna shock this place. I don't know if they'll ever get to the big crooks as the hourglass sand continues to, disappear, as the statute of limitations continues to approach. I don't know about that. Plus, the sheriff's going to be up for re-election in the not too distant future. Can't rock the boat too much on the people who support his campaign. You've got to think about these things. I'll be back and I'll show you this motion in limine right after this.
When your life is on the line, hire the lawyer who lives in our community, works in our community, and worships in our community. I'm Al Saulene, your Panama City Beach lawyer. 850-215-0628.
You want to look good? You want to feel good? Little John's Big and Tall is where it's at. Right across the street from Sky's Pizza Pie, 5700 North Davis Highway. You can find out more online at littlejohnsbigandtall.com. He's also a member of the iTex trading community, where your iTex dollars are welcome.
All right. I don't see how I can share I may not be able to share this. I don't know why I'm not able to share this. Let me try to pull up this motion, because if I can't show you tonight, I'm going to have to show you tomorrow. But I really want to show you tonight. All right. This is really something. All right, maybe they've changed this a little bit. Let's see. Present screen, huh? Oh, okay. I can show you. The program I use, called StreamYard, just changed the wording on it. All right, cool. Here we go. You should be able to see that. Let's go through this together, and let's begin. Let's see here. Let's begin at the end. How about that? So on the last page of this motion, it'll show you their conclusion. What are they looking to? What is the government looking to keep out of trial? Let's begin with the 15 things, and then we'll look through the 15 things in more detail, or through some of the 15 things in more detail. All right, here we go. Here is what the government, what the prosecutors are asking for. This court, they say, should enter an order that goes like this: admitting limited evidence about ECS, erosion control specialist, and world claim, which it has found to be intrinsic in the non-severed offenses and is probative of defendant Anderson's intent. So what the government is saying here is, we know, Your Honor, that you have removed some of the conspiracy charges for a separate trial, but you ought to bring it back. That's what they're saying here. All right, so All right. So that's the first thing they're asking the judge to do is bring back some of that conspiracy stuff. Also, number 2 out of 15, admitting evidence that defendants violated court orders prohibiting contact between themselves and witnesses, that defendant Finch hired and paid his attorney to represent defendant Anderson and defendant and both of their attempted concealment. All right. Now, remember, James Finch went on WMBB before he was indicted and told everybody in a live interview that he was paying for this. The government with unlimited resources says it is just not fair that you're spending so much money on your defense. All right. And the judge has already decided on that. Number 3, they want the court to exclude evidence, argument, or other reference to the jury that defense counsel, all right, had prior experience with the Department of Justice. What they're saying here is James Finch's attorney, Guy Lewis, well, he's a big shot. He used to be an assistant. He used to be under Ashcroft, Attorney General Ashcroft. He used to be the boss of all U.S. attorneys, Guy Lewis. And they don't want the jury to know that Guy Lewis has all this experience. It's not relevant, says the prosecutors. The jury should not know that this attorney has all that experience. Okay, so they want that out. The government wants to exclude evidence, argument, or other mention of defendant's health conditions, James Finch, or either of them really, except for defendant Finch's health condition in October, November of 2018. What they're talking about, the government says that James Finch and former Mayor Margo Anderson in October were plotting and scheming to enrich Finch with lucrative contracts after the hurricane. Now, the FBI, as you'll see, told the grand jury that during October of 2018, remember Hurricane Michael was October 10. In October of 2018, the grand jury was told that Finch was out of pocket, all right, but still involved in this conspiracy. Now, where Finch was actually was not out of pocket. He was in a coma in Jacksonville. He was in a coma October 4. Well, he went in October 4. The hurricane was October 10. He didn't get back to Lynn Haven from the hospital until something like October 30th, something like that, till the end of the month. He was there like the whole month. You're going to love what they have to say about this. It's you know, the prosecutors, the FBI, they didn't tell the grand jury that he was in a coma. They said he was out of pocket. You'll see in here. Number 5, the government wants to limit evidence, argument, or other reference to the former case agent, that's the FBI agent, to his, you ready for this, to his inadvertent errors in grand jury testimony to matters affecting a witness's credibility. In other words, what they're saying here is, Your Honor, we know that the FBI agent made a bunch of inadvertent errors to the grand jury in order to get the indictment in the first place. Now, to rehash that in front of a jury just to make his credibility look bad is not something the jury should see. It's not something the defense should be able to do. That's what they're asking for there. Number 6, excluding evidence, argument, or other reference to the quality or quantity of evidence before the grand jury. In other words, look, the evidence that was presented to the grand jury, whether it was good evidence or bad evidence, that should not be something the jury should hear about. Look at that. The quality or quantity of evidence before the grand jury. Who cares what the grand jury was told to get the indictment? That shouldn't be something the witnesses or the grand jury ever hears. All right, I'm looking at your comments too. There we go. That's exactly right, Miss Sarah. Prosecution doesn't want the jury in the courtroom to hear how they were able to get an indictment in the first place. That's exactly what that one's about. Number 7, Prosecutors are asking the judge to exclude evidence, argument, or other reference to the amount of time the grand jury deliberated before returning the second superseding indictment. So the first time Margot Anderson and James Finch were indicted, it got thrown out, at least the major part of it, the conspiracy part of it. So they went back to a grand jury and they said, look, the last grand jury, they did it. So we just need you guys to give us what's called a superseding indictment. And the grand jury deliberated for 120 seconds before giving them the indictment. And the government does not want the real jury to know that the second grand jury deliberated for 120 seconds with all the stuff you're seeing right here. Why wouldn't they want them to hear that? They want to exclude evidence or other reference to any alleged errors of fact or legal deficiencies in the original or superseding indictments. So they don't want the jury. The prosecutors are saying, Judge, the jury in the trial, they don't need to know that the first indictment we got was all jacked up. Why would they need to know that? They don't need to know what the grand jury was told. They don't need to know about the bad first indictment. It's just going to take up the court's time and confuse the jury. They want to exclude generally evidence, argument, or other reference to any alleged violation of DOJ policy or FBI policy. What that's about, I saw it in the evidentiary hearing in Tallahassee in March. The FBI agent, when he comes and interviews you, witnesses or targets. Hello, this is the FBI. This is Major Stanford with the sheriff's office, and we'd like to talk to you. Have you heard about this? Do you know anything about that? Do you have any documents we can see? All right. And then when they leave, the FBI agent is supposed to sit down and type up formally on a form called a 302. He is supposed to type up what happened in the meeting. According what I saw at the evidentiary hearing is that's part of the FBI policy is, look, after you do an interview with somebody, you write it up formally in a 302. But the FBI agent didn't do that for something like 2 years. I don't know, maybe not that long, 14 months, something like that. It was like unbelievable amount of time. He went back and wrote the 302 like several months after they had the conversation. And so that's part of the defense is how would he remember all that? And the prosecutors are saying, look, the jury doesn't need to know that. If the FBI agent didn't follow DOJ policy or DOJ FBI policy, why would they need to know that? The government is asking the judge to exclude evidence, argument, or other reference to allegations that the government violated the Sixth Amendment right to counsel. The jury doesn't need to know that the defendant may have had an FBI informant inside listening to their defense strategy, a violation of the Sixth Amendment. Why would the jury need to know that? Your Honor, that should not be heard. Number 11, they want to exclude evidence, argument, or other reference to details of the domestic violence incident involving former city manager Michael White. Michael White is the former city manager who has pled guilty to the stuff, but months prior got into an unbelievable domestic altercation with his wife involving a gun. And the sheriff's office says, well, it was when we arrested him on that, or when he was arrested for that or whatever, you know, we had his phone, and when we looked through his phone, oh my God, we found all this corruption in Lynn Haven. So their argument is that they discovered all this corruption in Lynn Haven by looking at his phone. And in trial, you'll hear more about that. unless the government's able to get that thrown out. Why would the jury need to hear that? Well, because that contradicts the main defense that Margot Anderson claims she is the whistleblower. On April 1st, 2019, she went to Sheriff Tommy Ford and told him that she had discovered like $5 million in fraudulent charges from ECS, Erosion Control Specialist, owned by Mickey White, Derwin White's nephew. All right. It was after that she was arrested. But the argument from the prosecutors is we knew all about it. We were already on that. She's just trying to cover her tracks. So we have to believe that and she submitted documents later to the sheriff. And those documents evidently implicated her in crimes. So we have to, they don't want the jury to think that the whistleblower blew the whistle on herself, right? Why would that be important? They want to exclude, the government wants to exclude evidence, argument, or reference to the alleged criminal conduct of persons who are not witnesses. Now, the reason this is important, and this was part of the evidentiary hearing, the lead guy in the public trust unit for the sheriff's office, Jimmy Stanford, he had to testify under oath in March. And he admitted to getting gifts from Derwin White, like motorcycles and stuff like that. But the government says we're not going to use him as a witness. And that's not criminal conduct anyway. But the defense is going to make a lot of this if given the opportunity. And of others who they might not bring up. So what they're saying is, look, if we're not going to bring up, if Major Stanford's not even going to be a witness, or other people are not going to be witnesses, then it's whatever. In fact, it says in the next one, excluding evidence, argument, or other reference suggesting that Major Stanford disclosed the imminent search of ECS to Derwin White. So Derwin White was tipped off that there was going to be a search warrant issued to on ECS, on his nephew's company that fraudulently billed Lynn Haven $5 million. He got a tip on that, evidently, the day before. The defense is saying that it was Major Stanford who told his old friend about it. And the government is saying that should never be told to the jury. Why would the jury need to hear that? That's, by the way, when Derwin White told Mickey White to plant the invoices the day before the search warrant. And the government says, why would a jury need to hear that? Why indeed?
Don't let back pain and neck pain get you down. Find relief at Brown Chiropractic Center on St. Andrews Boulevard in Panama City. Dr. Sherry Brown helps people heal naturally with chiropractic adjustments and deep tissue massage. Call 769-3777.
It's a hot time in Florida, and my friend Ryan could make sure your air conditioning is running at peak efficiency. He could even install a new one, built to a higher standard, American standard. Find out more at pcairrepair.com. All right, number 14. There are 15 things the prosecutors are asking the judge to keep away from the jury. They want to exclude evidence, argument, or other reference suggesting that, again, Major Stanford, the head of the public trust unit for the sheriff's office, that he improperly accepted things of value from Derwin White, like a motorcycle and other things that were discussed at the evidentiary hearing. Okay, so Derwin White evidently would give gifts to the sheriff's office folks, friends. They want to exclude evidence or other reference to prior allegations of misconduct by an attorney for the government. That's the lead prosecutor, Stephen Coons, who 15 years ago, I guess it was 20 years ago or so, got in trouble for accusing a family of murdering their infant child. He had claimed that he had, the same lead prosecutor in this case, Stephen Coons, he had claimed that he had bugged the house of the family, of the mom and dad, who he said murdered their child who went missing in the night, 5-month-old. And when he came to deliver the bombshell recordings that he had planted in their bedroom, he claimed that some of the stuff the dad said was, I'm something like, "I'm sorry I hurt her. It must have been the cocaine." What? The dad is on audio saying, "I'm sorry I hurt her. It must have been the cocaine." Well, man, that sounds like smoking gun evidence. Let's hear it. So Stephen Coons goes to the court and they play it. And here's all you hear. You can't hear anything. Nancy Grace was shocked. Remember Nancy Grace? Yeah, Nancy Grace was covering the case. And she was saying, "Oh my God, the prosecutors are about to play it. Let's take a listen." And you couldn't hear a word. It's the lead prosecutor in this case. And so the government is saying that when we go to trial in November, the jury doesn't need to know that our lead prosecutor did that back in 2002 or something. and the Department of Justice paid the family like $2 million for that. The case was dropped after they found out that the recordings that were in the bedroom of the mom and dad was nothing but scratch. You couldn't hear a word. Nancy Grace had her audience all hyped up. And then they listened, and it was nothing but static. And do you know what? I hate to get into all these details, but I have to. They're going to be so mad at me about this. But you need to know this. Stephen Coons told the judge at the time, the lead prosecutor in this case told the judge at the time, "I know there's nothing worse than losing a child." And the judge interrupted him. And the judge said, "Yes, there is, actually. Accusing the parents of murdering their child, that's worse. With no evidence. Throw that out." They had to throw out the static evidence that the lead prosecutor said he had. The case fell apart, obviously. And the Justice Department, the U.S. Justice Department, came in and paid $2.5 million. It's like the biggest mistake ever made, ever admitted to by the Department of Justice. So Coons was taken off. And he landed on his feet back here. And he's the lead prosecutor in this case. And the government is saying, look, the jury doesn't need to know this. But the defense is saying, we sort of feel like this is deja vu. So this is what was filed today. A motion in limine. I'm always trying to impress the lawyers who are now evidently walking around the courthouse saying, Bernie, the attorney, knows his stuff. That's what they're saying. The shadow knows. Oh, boy. So let's take a look at a little bit more detail on this. Let's take a look at some of these last few. All right. Which ones? The court should exclude. Yeah, let's start right around here. Let's start right around 6. Yeah, okay. So look at this. The government is saying the court should exclude evidence, argument, or other reference to the quality or quantity of evidence before the grand jury. So in other words, what originated this whole thing, what the FBI agent told the grand jury, yeah, might have been false, but, doesn't mean they're innocent. You don't believe me? Listen to this. The Supreme Court has said that a defendant cannot challenge an indictment by complaining about the quality of adequacy of evidence before the grand jury. Okay? Now, the difference is, I'll say this. The difference is, this is one of the less than 1% of these cases, the grand jury testimony transcript is actually given to the defendants. Most of the time, the defendants just claim that they must have lied to the grand jury, but they never know because it's a secret. In this case, the judge unsealed that grand jury testimony, the transcripts. So now they actually have proof of it. So it follows that evidence, argument, or other reference, says the government, at the trial is not permissible. We can't tell them that the quality of evidence in the grand jury wasn't that good. Wrong. It has no bearing on the issues and would simply waste time and confuse the jury. The court should exclude evidence, argument, or other reference to the quality or quantity of evidence before the grand jury. Okay. Here's their argument for the next one. The court should exclude evidence, argument, or other evidence to the amount of time the grand jury deliberated before returning the second superseding indictment. They did it within 120 seconds, but I'm going to skip over that one. The court should exclude evidence, argument, or other reference to any alleged errors of fact or legal deficiencies in the original superseding indictments. In other words, the original indictments, yeah, we got a bunch of stuff wrong, and that led to all this stuff, but doesn't mean they're innocent. And the jury doesn't need to know we screwed up. Listen. Defendant Finch's counsel, halfway down, expressly stated in writing, we will offer more than a dozen of these kinds of disturbing and extraordinary government mistakes in the first indictment at trial or the second indictment. A superseding indictment replaces the original indictment, the government says. An error in an earlier indictment is not relevant to the question of a defendant's guilt or innocence on charges in a superseding indictment. Just because we got it wrong to begin with doesn't mean that the second one's not right. The court should exclude that, they say. Number 9, the court should generally exclude evidence, argument, or other reference to any alleged violation of DOJ policy or FBI policy, all right? Even assuming there was a violation of any internal policy. Those allegations are not relevant for the issues before the jury. Any allegation of misconduct on the part of an attorney for the government, same guy we've been talking about, who is not a witness, is not relevant for the jury to determine if the defendants committed the offense as alleged. In other words, look, just because the lead prosecutor screwed up years ago, he's not a witness in the case. This trial is not about, look, the prosecutors and the investigators are not on trial here. By the way, that's really what they're saying. And they say it in here somewhere. The point of this whole thing is the defense is going to try to make it look like we did a bad job, that we took bribes, that we lied to get an indictment, that we have a prosecutor who has been involved in malicious prosecution in the past, that the evidence was not real. But we're not on trial here, okay? They're on trial. And the jury doesn't need to hear any of this stuff about us. That's what this is all about. How do you defend yourself? The judge has already rebuked the investigators and the prosecutors, saying that they're unprofessional, their conduct is unprofessional, haphazard, and reckless. And by the way, The judge 20 years ago in the Eisenberg case I've been telling you about, to the same lead prosecutor, also used the word reckless. I've got to tell you this stuff, right? God, you wouldn't believe how mad they are at me. I have to tell you this stuff. Do you know how dangerous it is to tell you this stuff? It's really dangerous to tell you this stuff. And I can't get into details right now. But it's unbelievably dangerous to tell you these things. When the time is right and the mood is proper, I suppose. I should not feel scared to tell you these things. I should not have to be worried that bad guys are going to kill me. I should not have to be worried that law enforcement is going to set me up. I should not have to be worried that I'm being surveilled because I'm reporting this stuff. But I am. And that's why all of this stuff is spread around. So if anything happens to me, you're still going to get the truth. This is really, really insane. But I'm going to continue to tell you this stuff. All right. You know, one of the hardest things to do is to decide when to tell you things. Because, you know, you want to be right, but you don't want to be dead right. Right? Have I told you how happy I am in my life? Have I mentioned to you that I love life? I feel like who was the rapper that got convicted and he was screaming, I'm not going to kill myself as they were hauling him away. I feel like that. All right, back to this. I'm sorry about digressing, but you know, as I'm telling you these things, all of these things are flashing through my head that have happened to me recently that are unbelievable, off the chain, crazy, dangerous, illegal messages. But I'm going to continue to tell you this. All right, here we go. We are again talking about the filing today by the prosecutors who are asking the judge not to show the jury in the Lynn Haven case. We don't show the jury all the places we've messed up. We've made false statements. We've taken gifts from targets. Please don't let the jury hear that stuff, Your Honor. We can't get a conviction if they hear this stuff. Like, for example, when the FBI agent interviewed somebody and didn't write it down for, like, I don't know how long it was, a year and a half, a violation of the DOJ policy and FBI policy. And it says right here, even if there was a violation of internal policy, those allegations are not relevant to the jury. Any allegation of misconduct on the part of an attorney for the government who is not a witness is not relevant for the jury regarding a testifying FBI agent or other law enforcement officer. Counsel should be able to inquire into instances of misconduct. However, any allegation of misconduct must be probative of truthfulness. All right. Then it goes on to the case law. Number 10, there are 15 things the government doesn't want the jury to see. Number 10, the court should exclude evidence, argument, or other reference to allegations that the government violated the Sixth Amendment to the counsel. All right. And that goes into where an FBI informant was listening in on some of the strategies of James Finch, and they thought Derwin White before he died, but he died, I think, at the end of July of last year of COVID. Number 11, the court should exclude evidence, says the government, to details of the domestic violence incident involving former city manager Michael White. They say that evidence found in his phone during the following domestic violence investigation eventually led to the discovery of the ECS fraud in the search of ECS, not Margot Anderson, on April 1st, going to Sheriff Tommy Ford. That's not why. It was because of all the stuff we found on Michael White's phone, the former city manager. Okay, so number 12. The court should generally exclude evidence, argument, or other reference to alleged criminal conduct of persons who are not witnesses. All right, let's see if I get this right. You know, earlier I had mentioned Deputy Jimmy Stanford on this one, and I was wrong. This is referring to these people. The next two are have Major Stanford's name in there, but I was wrong on the referring to this. Defendants have signaled an intent to base a defense to the criminal charges against them by pointing the finger at others. So, look, Your Honor, Margot Anderson and James Finch, they're going to say they're innocent because other people did it. All right? And they shouldn't be allowed to do that. In particular, at the evidentiary hearing, in written filings, in communications with the government, the defense has suggested that Derwin White and Chris Forehand, now Chris Forehand was the city engineer, the engineer that the city contracted. They're the real conspirators, comparing them to hubs, spokes, and a rim, according to the defendants. And, well, there's more too. We saw that got resealed. So in other words, Your Honor, they shouldn't be able to ask the city engineer. They shouldn't be able to bring him up there and ask him all kinds of questions in front of the jury about World Claim and ECS and Michael White and all kinds of stuff. They shouldn't be able to point fingers at other people, especially Chris Forehand. Now, that's incredible that they're, I guess it's normal. I guess that's just what they do. But let me tell you something. If the defendants can't, what does it say? If they can't argue that there was criminal conduct by the city engineer, if they have evidence of it, we didn't do it. Actually, look at this. Then they have no defense. You know more than anybody I want to clean up this town. So to see the Keystone Cops on crack focused on this, well, hell, everything I've told you for the last 4 years, it feels like it's not true. Oh, they're going to clean up corruption, man. Sources tell me that they are really focused on cleaning up corruption. I've been telling you that for how long? And now I see this? All right. Look at this. Derwin White is deceased, and naturally he will not be a witness at trial. to the extent he was personally involved in the transactions of this case, say, telling his nephew, Mickey White, to create invoices regarding work done at Anderson's home, planting evidence, the jury shouldn't hear that. That limited information may be relevant and admissible, but what is not relevant and admissible are broad accusations that Derwin White was, as defense counsel has asserted, orchestrated a massive conspiracy. If true, that has nothing to do with the merits of this case, whether defendant Finch bribed defendant Anderson and lied about it to the FBI. You know, the difficult thing about this, when you look at it all, is the prosecutors want you to believe two things at the same time. On many areas, they want you to believe that the whistleblower blew the whistle on herself. They want you to believe that her lifelong friend and co-defendant was the impetus of having Derwin White have his nephew plant evidence against her that led to his indictment. Number two. Number three, they claim that James Finch, while he was what did they say? Out of pocket, in a coma. They didn't say in a coma. While he was in a coma and out of it all of October when the hurricane hit. They want you on one hand to believe that he was mad that Derwin White was getting all the business while he was in a coma. But at the same time, they're tied at the hip. You've got to believe all of these things at the same time. What we saw, and here's what really ticks me off. What we saw in the search warrant affidavit that was unsealed and then sealed again real quick. What the FBI told the judge had Chris Forehand all over it. Had Alan Betts all over it. George Gaynor, Joel Schubert. What the FBI told the judge to raid GAC contractors is not, in fact, it contradicts what we see here. And the government's saying the jury shouldn't know that. They shouldn't see this stuff. It'll confuse them. Defendants cannot properly assert at trial that they're not guilty because he did wrong. Okay. Look at that. James Finch was joined at the hip with Derwin White. The whole argument is James Finch was mad that Derwin White was getting all the business. And so he and Margot worked together to get him business unfairly. That's their argument. But that's not what they told the judge, and that's not what they're saying even here. Unless the defense proffers a basis in admissible evidence, the court should exclude evidence, argument, or other reference suggesting that Bay County Sheriff's Office Major Stanford disclosed the imminent search of Derwin White. The defense says, we have now uncovered direct evidence that this same co-investigator leaked information about this case, including the timing of when a search warrant would be executed. Now, the government itself says this. It is undisputed that Derwin White told Mickey White to make invoices for defendant Anderson's property and two others the day before the search. What? This is like 5 months after she was this like 5 months after she was indicted? There is evidence that defendant Finch prompted this by telling Derwin White. There's evidence that defendant Finch prompted this by telling Derwin White that defendant Anderson was going to the sheriff. Think this through. There is not evidence that Major Stanford leaked information to Derwin White. Evidence, including Derwin White's phone records and Major Stanford's testimony, tend to disprove that accusation. So what they're saying is, look, the defense is saying that Major Stanford told Derwin White they're going to raid Mickey's place tomorrow. But Major Stanford says he didn't do it. See? So the jury shouldn't hear this. Does that make sense? The court should exclude evidence, argument, or other reference that Major Stanford disclosed the imminent search. Number 14. The court should exclude evidence, argument, or other reference suggesting that Major Stanford improperly accepted things of value from Derwin White. Major Stanford testified, it was in March, the evidentiary hearing in front of Judge Walker in this case, that he received a motorcycle from Derwin White in 2010 and got some work done on his house years before the events of this case. And there was more that Major Stanford went back and admitted to later. The government does not intend to call Major Stanford as a witness. Well, the defense might. If you were a defendant, would you call him as a witness? Hey, did you tip off Derwin about the search warrant where evidence was planted that landed me here? That at least should be asked in court. But the government says absolutely not. You don't question us like that. We're not on trial here. You are, Jack. Nor can the defense call Major Stanford. Oh, here's what they say. The government does not intend to call Major Stanford as a witness, and the defense cannot properly call him as a witness solely to impeach him. Nor can the defense call Major Stanford as a witness solely to cross-examine him about irrelevant information. You're not going to harangue our guy here. He's the head of the public trust unit. He's in charge of the sheriff's public trust unit, Major Stanford. You're not going to sit here and question the guy. What's wrong with you? You're the one on trial. I don't think the judge is going to grant that. And I think what we're going to see at trial, if it goes to trial, if the judge doesn't throw this whole thing out as a friggin' circus, which it is, if it goes to trial and the sheriffs have to sit up there and answer these questions and there's evidence presented that doesn't look good, you know how bad that is for our community? Actually, any evidence that reveals the truth about our community is good for the community, but it might shock us. Look at this. Derwin White told Mickey White to do it, and he did. Well, how did he find out? I want to know when there's a search warrant coming. I want a little tip. Number 15, and finally, as we come to an end here, the court should exclude evidence, argument, or other reference to prior allegations of misconduct by an attorney for the government. That would be the lead prosecutor I was telling you about. Prior cases involving the lead prosecutor in this case and allegations of misconduct. Now, the jury doesn't need to know about that. All right. You know, I wanted to show you something else too before we go. This is the most petty and unbelievable part of the whole thing to me. What you're going to see is so unbelievable. Oh my goodness. Okay. I'll post this whole thing for you to read too. Okay, here we go. You ready for this? Now remember, okay, this is so important. Remember that Hurricane Michael hit on October 10. This whole thing said the government claims that James Finch was pissed because he was out of pocket. All right, he wasn't here able to get those contracts because he was out of pocket. And he was pissed that Derwin's getting all the work, see, even though he's supposed to be tied at the hip with him. And so he gets back to town after the hurricane and he starts, calling meetings, and he and Margot start getting that money. They start making sure by themselves right? By themselves. They were able to get all the contracts without votes. All right, but I want you to see this. This is incredible. Remember when you read this, that in reality, James Finch, from October 4 to the end of October, was either in a coma or recovering from a coma, from a brain bleed. The whole month. Remember that. He was in a coma and recovering from a coma. But this is how it was described to the grand jury, and still to this day. All right. The hurricane struck halfway down. October 10, ECS received lots of money from the city for hurricane cleanup and committed a large fraud in the process. Defendant Finch was somewhat out of pocket for the rest of that month. Mark this, 1 minute into the show, 1 minute, 55 seconds into the show. If you say, Bernie, what is the most disgusting part of all of this? It might be that. Defendant Finch was somewhat out of pocket for the rest of that month. Look, if you were in a coma and the federal government said this about you, even if your name is Hector Solis or Mike Thomas, I would say I would come to your defense. I would say, actually, the way that should read, the way that should read is defendant Finch was in a coma. He was in Jacksonville recovering from a coma. Maybe he got back and maybe James was able to just, spring right back out of it. Maybe he had a coma, a brain bleed, and boy, boom, like that, he was back on his feet. But at least you should say it was a coma, not somewhat out of pocket. This is so disgusting to me. This is like, petty's not even the word. What do I say? What would you say? Anyway, Finch was somewhat out of pocket, but he was still ticked. He wasn't getting all the contracts. So Margot and him were going to work out the second he gets back. All right. The evidence indicates, says the lead prosecutor, that had planted the audio recordings in the bedroom of the family that he said murdered their baby. Same guy. The evidence indicates that defendant Finch was not pleased that he was missing out on a lot of lucrative city business. The evidence indicates that while he's in a coma, he's pissed off that he's not getting these contracts and Derwin's getting the contracts. But yet at the same time, they're tied at the hip. This is what I'm talking about. We are spending all of this time on this when we know, I've shown you, that real criminal activity has occurred here, that the pickup of hurricane debris was extended, prices were inflated, kickbacks were given. And this is what they're talking about. Yeah, I'm more than a little perturbed about it right now, honestly. Defendant Finch was not pleased that he was missing out on lucrative city business. Among other things, while defendant Finch was partially indisposed, what's a jury going to say? He's in a coma, and you say he's partially indisposed and somewhat out of pocket. I mean, that's sadistic. Is that sadistic? Or am I Bernie, he probably was in a coma, but, he's so greedy. He's got one eye open. And when he's not looking down the nurse's blouse, he's rubbing his hands together under the blanket thinking, I need to get a hold of Margot. Got to get a hold of Margot. Got one eye open. He probably had his cell phone under the blanket, just pretending to be out of pocket, trying to peek down the nurse's blouse, James. And when the nurse left, boy, he was only partially indisposed. And boy, he gets back when did he get back? At the very end of October? And James is a spry chicken, boy. He's calling meetings. He's running around trying to get everybody to. You see what I'm talking about? I just had to share that with you before I signed off. So the government doesn't want the jury to know all this stuff, but I'll post this whole filing for you. I might not do it tonight. I'll look at my. I gotta get some stuff fixed. I probably won't do it tonight because I'm really. I've had enough of this tonight. But I got a lot more to tell. I got so much to tell you. And again, there's a lot you need to know. There's a lot you need to know. And if you want to support my efforts, here's how you can. You say, Bernie, independent journalism, watchdog journalism, where it's at. Please keep giving us the truth. Please keep the lights on in the Liberty Lounge. Please keep things going. I'll do my best. And I hope that you'll help by becoming a patron at patreon.com/Bernie Thompson. It's anonymous, it's easy, and it is, you can quit at any time. Patreon.com/Bernie Thompson. Crowdfunding helps support these efforts. And as always, so does the Unknown Patriot. Thank you so much, Unknown Patriot, for your support. And I'm going to sign off. I'll read your comments later. But things are going to start to snowball now. So soon we'll find out what the judge is going to let the jury hear, what the judge is not going to let the jury hear, if the judge is going to continue to tolerate the unprofessional, haphazard, and reckless misconduct of the prosecutors. We'll see. And if it gets to trial, the cross-examinations, the witness testimony is going to be a barn burner for sure.